Back in November of 2017, Franklin Tyrone Tucker took part in a botched robbery that turned deadly. Tucker allegedly initiated the robbery when he found out that there was a large sum of money being kept in a treehouse located in an area known for high crime in the Florida Keys. Tucker had an advantage over Matthew Bonnet, the victim, who tried to prevent the robbery from taking place. The struggle left Matthew with 5 stab wounds, which ultimately resulted in his death. This is known as the treehouse murder, where Tucker was charged with a number of felonies, including first-degree felony murder and witness tampering. At one point, Tucker went so far as accusing the prosecution and the judge of being in cahoots and working together against him. Leading up to the trial, Tucker had different attorneys representing him, but ultimately filed a motion to represent himself, which was granted by the judge.
What did you want to say, sir?
Well, Your Honor, to be quite frank, I'm going to go ahead and file a motion to disqualify tonight. So we're going to have to consider that.
Okay. That's fine.
Okay.
You can.
That pretty much ends the conversation right here, doesn't it?
No, sir, not at all.
I mean, because look, I am doing my best to make sure my witnesses are here.
Sir.
Right, but I'll tell you what, it's not exactly easy when first off, I have to go through the clerk, which they don't have to do. But not only that, you know, we did go over and we had overlap, Your Honor. There, you know, that is the way it is. Now, I just confirmed my witnesses. Right? Now, they want to say that Tom Walker, because they're thinking I'm going to go to, see, this is the thing, they're thinking I'm going to go.
This is inappropriate.
But no, there's been evidence that has been tampered with, and we need to figure out which ones. Tom Walker has that knowledge. You know, I mean, that's the bottom line. I mean, I don't know which videos have been tampered with. I don't know which ones, you know, haven't been. I don't have that list. Tom Walker does.
So first of all, when a defendant, either through themselves, if they're representing themselves, or through their attorney, wants to disqualify or recuse a judge, they have to file a motion in writing. It can't be oral like this guy's trying to do. And once that motion is filed, everything has to stop. The proceedings have to stop until the judge rules on the motion. And there cannot be any commenting on the motion. In other words, the judge can't say, well, this is a ridiculous motion, or this is unfounded. The judge, according to the law, either has to say granted or denied, legally insufficient. This guy's smart. He's trying to cause a delay in the trial by mentioning this motion to disqualify. However, an attorney would have known, I need to put it in writing if I want to stop the proceedings.
When I got arrested, because Detective Pitcher was one of the ones who talked to me when they were doing their interviews. And I remember him leading the charge, but there was a good amount of officers, and they were coming in from both sides. And I remember looking up at him, and I was like, I guess we're not talking now, are we? And he's like, no. And so they arrest me, and they take me over to the jail, right? And and the whole time I'm kind of flipping, and I'm like, literally, I'm like telling them I didn't have anything to do with this, and and so I'm telling him this stuff, and somewhere along the lines I get told that it's about witness tampering, right? And I'm like, and I thought it was over Paula. I thought it was because I talked to her at McDonald's. I was like, nobody told me I couldn't talk to her, right? But that's not what it ends up being about, and I won't testify as to what it was because I think that would Mr. Mansfield probably object to it. But at the same time, so so I'm thinking, again.
It's just like a rambling stream of consciousness.
Now I'm in jail.
Ineffective.
And they take me, and they literally, the jail has the elevator, goes up, they take me in. I remember.
I mean, does anybody care about the jail elevator?
Whatever the hell, whatever that is, where they check you in, whatever, right? But they do that, and this is, I'm not going to say I haven't been to jail before. I've been to Key West jail one other time, and it was for misdemeanors, right? Boat charges, it was nothing. I mean, I can't say it was nothing, but, it was misdemeanors.
He's rambling. He's talking about jail elevators. He's not making eye contact with the jury. He's just rambling, like he's talking to a therapist or talking to his lawyer, telling the story initially. Well, these are details that the jury's probably waiting on the edge of their seats, wanting to hear what actually happened. And rather than saying, I didn't do this, he's saying, I told the detective that I didn't do this, and da-da-da-da-da, and I went to the jail, and I went up on the elevator. Like, no, that's not how you present your testimony. Again, if a lawyer was helping him, the lawyer could interject himself or herself and say, sir, let me stop you right there. Tell the jury how this event happened. When did you make contact with the police? And then if he starts rambling, a lawyer can say again, sir, let me ask you another question, and then interject so that the situation is told in a logical manner so that the jury can follow along and know from his point of view what he believes happened or what happened. This is not an example of that.
Yeah, I went down to the station. I was there all night. You have to, again, I can't tell you how the interrogation or the interview went. I can't tell you what they told me. I can't tell you anything about that.
The prosecution should be objecting.
It is very frustrating, not to be able to provide you with any of that information.
Or maybe they're just letting him
and again,
dig his own grave.
Mr. Mansfield also alluded to, nothing being tampered with, nothing, being was it mishandled or whatever. Again, I'm not allowed to talk about that.
Judge, again,
Objection.
There's no evidence of mishandling of evidence or
Again,
In any event, we're going to, members of the jury, remember this is closing argument, all right? And it's based upon the evidentiary record.
What the
and
attorneys say and what the pro se
limited to
defendants
the
say is not
both
evidence.
sides that is in the trial. Not beyond that, so Mr. Tucker can certainly make arguments pertaining to the evidence in the trial.
okay.
In terms of rulings that the judge made, that's really not for jurors' consideration.
It's not. It's not really not. It's not.
I would just submit that.
And he should not be
by
able to
saying
bring
what
up
you
in
just
closing
said,
argument
it's again,
things that
you're
he
going
can't tell
beyond
he's
stuff
been
that's
ordered
been
not to tell the jury.
admitted into the trial.
Well, but in any event,
But
just
I'll
continue with
watch
your
myself.
argument.
I'll watch.
This is completely inappropriate. If a judge tells you you can't get into this, you can't explain, I assume the reason he can't get into what he told the police is probably because he invoked his right to remain silent, or what the police told him. I'm assuming that at some point throughout the interview, he invoked his right to remain silent and his right to have an attorney, which means the interview stops, and at trial, the prosecution can't mention that interview because you're not allowed to comment on a defendant's right to remain silent. What he's essentially doing right here with his closing argument is telling the jury that the cops interviewed him, but he can't talk about it. To me, that opens the door so that when the prosecution gets up on rebuttal, they should be able to explain to the jury why it is that the judge ruled he can't talk about his statement. Otherwise, it's unfair and looks like the prosecution is trying to hide something. This sort of bantering back and forth and talking about things that are not relevant, like, well, they arrested me and I spent the night in jail and all this kind of stuff, while he's casually looking down at his notes and talking. Like I said, it is almost always a bad idea for a defendant to represent him or herself. But why not have somebody who's trained in the presentation of evidence and the rules of evidence and who knows how to conduct a trial be able to package up your case and present it in a way that the jury is going to understand and possibly side with you. In the end, he raised enough reasonable doubt to convince at least one juror that he was not guilty. The trial ended up in a mistrial because the jurors could not come to a unanimous decision and the judge was forced to declare a mistrial.
I accept that fact. I'm going to declare this case a mistrial. So with that, I'm going to give you a final instruction here, ladies and gentlemen. I wish to thank you for your time and consideration of this case.
And, when it's tried again, in my opinion, this guy needs to have the assistance of counsel. In my experience, I have never seen a person who represents themselves get any type of benefit. In fact, I would go so far as to say every person that I have ever encountered that has chose to represent themselves did themselves a disservice both before and after trial. Also, a person cannot claim on appeal that their own ineffectiveness in representing themselves is a reason for appeal. So while many defendants who are convicted have numerous grounds to appeal and can even complain about their own lawyer and the way their lawyer handled certain situations, a defendant who represents themselves during trial and is convicted cannot use those same arguments to say, I was ineffective. So they're assuming the risk. Okay, jury, it's your chance to give the verdict. Is the man who represents himself a fool? That's all we have on today's docket. Court is in recess. We'll see you next time. Please follow me on Instagram at j.elizabethshear and on YouTube at TheJudgeLiz.